Welcome to our deep dive on visiting the United States while your spouse-based immigrant visa is pending. In this video, we will clarify why this topic is so complex, outline the risks at the border, and provide practical strategies if you decide to visit. We will also include quizzes to reinforce key concepts and diagrams to visualize the process.
Now, to set expectations, let's preview what we'll cover next.
Here is our roadmap. First, we will explain the core legal conflict between immigrant and non-immigrant intent. Next, we will cover the power Customs and Border Protection officers hold. Then, we will show how to minimize risk if you still decide to visit. After that, we will visualize the decision-making flow, compare visiting now versus waiting, and test your knowledge with short quizzes. Finally, we will wrap up with key takeaways and next steps.
With that in mind, let's begin with the fundamental conflict.
This presentation is educational and does not create an attorney-client relationship. Immigration cases are highly fact-specific, and laws and policies can change. You should consult licensed immigration counsel before making travel decisions.
With that clarified, let's break down the fundamental conflict that drives this entire issue.
When you file for a County Route 1 spousal immigrant visa, you formally express the intention to immigrate permanently to the United States. In contrast, when you enter using a visitor pathway like a B-2 visa or the visa waiver program, you must assert that you are visiting temporarily and intend to depart. This creates a direct conflict. The very existence of a pending immigrant petition is often treated as prima facie evidence of your intent to immigrate. As a result, while the law does not outright forbid visiting, the burden of showing you are a genuine temporary visitor becomes much more difficult. In other words, the visit is legally possible but practically risky.
Now that we understand the conflict, let's move to the source of risk at the airport: CBP's discretion.
Customs and Border Protection officers have significant discretion at the port of entry. The legal burden rests on the arriving traveler to prove they qualify for admission as a visitor. If the officer suspects malintent, such as using a visit to bypass the long immigration process or planning to overstay, they can deny entry on the spot, cancel travel authorization, and issue an expedited removal order. That order commonly results in a 5-year bar to re-entry.
Reports vary. Some travelers are admitted without incident while others face secondary inspection or denial.
Because the stakes are high, your preparation matters.
Next, we will visualize what typically happens during a border encounter.
This sequence diagram illustrates the typical flow. First, the traveler arrives and passes airline document checks. Then, the traveler meets a CBP officer for primary inspection. If the officer has concerns, the traveler may be referred to secondary inspection for more detailed questioning. In secondary, the officer evaluates factors like the return ticket, employment or enrollment letters, housing evidence, financial ties, stated length of stay, and the nature of the luggage. After reviewing, the officer decides whether to admit the traveler as a visitor or refuse entry. If refused, the outcome may be withdrawal of application for admission or an expedited removal order that often entails a 5-year ban. If admitted, the traveler receives an I-94 and must depart on time.
With the process mapped out, let's discuss how to lower suspicion if you still choose to visit.
If you must visit, keep the stay short. 1 to 2 weeks is a safer window that visually demonstrates a life anchored outside the United States. Maintain strong, provable ties to your home country: an active job, a lease or mortgage, and ongoing bills or obligations. Always carry proof of those ties. Book a non-flexible, confirmed return ticket that is close in time, and be ready to show it. Pack minimally to avoid the appearance of moving personal belongings, and avoid bringing household goods. Finally, prepare to explain your visit succinctly: who you are visiting, why, where you will stay, and when you will leave.
Consistency and documentation are essential.
Next, let's compare visiting now with waiting until the immigrant process is complete. Visiting now gives you time together and may proceed smoothly when the visit is brief and well documented. However, there are substantial downsides. A denial can be emotionally and financially costly. Worse, an expedited removal order typically triggers a 5-year bar and can complicate future applications. The unpredictability of border inspection adds stress, and even a withdrawal of application can appear in records. Weigh the short-term benefit of a visit against the long-term consequences. With that comparison in mind, let's capture the key do's and don'ts in a concise, markdown-based checklist. Here is a practical checklist. Do keep your visits short. Do carry proof of strong ties such as employment letters, a lease, or bills. Do have a fixed, confirmed return ticket scheduled soon.
Do not pack as if you are relocating. Avoid excess luggage. Do not suggest that you might extend your stay or engage in work. Do not assume previous successful entries will guarantee admission this time. With fundamentals and checklists covered, let's test your understanding with a quick quiz.
Quiz time. The question is, why is visiting the United States on a B2 or ESTA while a County Route 1 is pending particularly risky? Option A, because visits are illegal once you file for County Route 1.
Option B, because immigrant intent conflicts with the required non-immigrant intent for entry.
Option C, because airlines always report travelers to CBP. Option D, because the embassy must pre-approve every visit. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is, because immigrant intent conflicts with the required non-immigrant intent for entry. The pending spousal immigrant visa filing signals the intention to immigrate, which directly conflicts with the temporary intent required to be admitted as a visitor.
Second quiz. The question is, which action most helps demonstrate genuine temporary intent at the border? Option A, packing multiple suitcases of household items. Option B, open-ended return ticket with flexible dates. Option C, a short stay with a fixed return ticket and proof of job and lease abroad. Option D, explaining you might extend your trip if things go well. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video.
The correct answer is, a short stay with a fixed return ticket and proof of job and lease abroad. These factors work together to demonstrate a coherent plan to depart and maintain residence outside the United States. Consider how these scenarios appear to a CBP officer. In Scenario A, a 10-day stay, light luggage, a fixed return ticket, and documents proving employment and housing all align with temporary intent. In Scenario B, a 6-week stay with heavier luggage and no employment letter raises questions, even if it may still be admissible. In Scenario C, a multi-month stay with multiple suitcases, weak ties, and statements about possibly extending resembles an intent to reside, which greatly increases the likelihood of refusal or expedited removal. Now, let's distill everything into the essential takeaways. These are the essential points. A pending County Route 1 complicates your ability to prove temporary intent.
CBP officers exercise broad discretion, and the burden of proof is on the traveler. Short and well-documented visits reduce risk. Strong ties to your home country and fixed return tickets are crucial. Finally, each entry is a fresh decision. Prior admissions do not ensure future ones. To conclude, let's summarize and point you to next steps.
In summary, visiting while your spousal immigrant case is pending remains legally permissible but practically risky. The possibility of expedited removal and a resulting 5-year bar is real. If you must visit, aim for short durations, bring strong evidence of ties abroad, maintain a firm return itinerary, and travel light. Above all, consult qualified immigration counsel to assess your unique circumstances.
To close, let's wrap up with a quick thank you and a call to action.
Thank you for watching. If you found this helpful, please like the video, share it with a friend going through the process, and subscribe for more clear explanations on complex immigration topics. Tell us in the comments how you are balancing the desire to visit with the risks at the border, and what questions you want us to tackle next.